Hello, everyone. Good afternoon, and welcome to this week's Business in 2021 webinar presentation. My name is Kathy Purdy. I'm Marketing Manager here at Bond. I'd like to go over two quick housekeeping items before we do get started. If you would enter your question using the Q&A box located at the bottom of your screen, our presenters will do the best to address those as time allows throughout the program. Once the webinar has ended, we would appreciate it if you would take a moment to complete the survey. Your comments and suggestions are important to our panelists and provide us with topics for future presentations. It is now my pleasure to introduce today's moderator, Andy Bobrock.
Kathy, thank you very much. Good to be with you. Good to be with everyone here on the webinar. Thank you for joining us. We do have a number of, I think, timely and insightful topics to cover today. I want to get going on those without any delay. First up, we have my partner and longtime friend, Pete Jones, on. Pete is going to talk to us about the developments that we are continuing to see on the issue of vaccination mandation. This is something that we're talking about with our clients on a regular basis, something we're discussing internally here. And I know Pete has prepared some helpful insight and we'll be walking everyone through the latest on this. Pete, thanks a lot for joining us.
Thanks, Andy, and good afternoon, everyone. It's good to be here today. I'm going to cover some of the things that I did last week because there's some updates. Last week, we talked pretty much about the healthcare mandate. But today, I'm going to talk a little bit more broadly about mandates generally and some of the considerations and the issues that we're seeing. So I thought before we jump into the particular mandates that we've seen, it's worth asking a few questions. First of all, whose mandate is it? And in New York State right now, you've got the potential to have overlapping mandates or at least multiple obligations. New York City has a couple of different mandates that are in place depending upon what industry you're in or what kind of employer you are. The state has come out with some mandates, a mandate for, in particular, for healthcare workers that has received a lot of press. And then there are some federal mandates, some that are on the way and some that are already here. So we're going to talk about all of those. But the fourth possibility here, of course, is your own mandate, some sort of employer decision to go with some form of a mandate to preserve the health and safety of your workforce or the people with whom you interact, et cetera, et cetera. So that's the first question. Who is imposing any mandate that we may be considering? The second is, what kind of mandate is it? And I think early on, the thing that we saw most prevalently was a sort of mandate that said, you either have to show us proof of vaccination or there'll be some sort of testing out requirement. Some people that I know have actually characterized that as a testing mandate with a vaccine out. You could think of it either way, but the point is that you could do one or the other. And so even though it is often referred to as a mandate, it is not a requirement if you give somebody another option such as testing out. Second thing is, what is the scope of the mandate? And we've been talking about exemptions. Everyone's probably now very well versed with the EEOC's position that you ought to have a medical exemption process and a religious exemption process. That has been really present in EEOC guidance since, I think it goes all the way back to the end of last year. It's been updated and refined a little bit. And those are to meet your obligations under the Americans with Disabilities Act and Title VII of the Civil Rights Act with respect to religious accommodations, to consider whether you've got some sort of obligation to accommodate people who have, for some reason, can't get a vaccine or have an objection to a vaccine. And then the third thing I think in this category is when, the effective date of those mandates. Again, if it's your own mandate, you can set that effective date. For the government mandates, we've seen a variety of different dates, and we'll go through some of those. The other thing that we've seen is, do they need to be fully vaccinated as of the effective date, or only have at least their first course of however many shots they're going to get. Of course, with Johnson & Johnson, your first shot is your only shot. But with the other two vaccines that have been approved at this point for administration in the US, it's a 2-shot course. So effective date is going to be critical too, and some lead time so that employees can make that choice about whether they want to get vaccinated, apply for an exemption, or possibly even just leave your workforce. Okay, next question that is going to be an overriding question here is, what are the consequences for people who do not get the vaccine? One obvious consequence could be separation from employment, but there are others. There's a leave of absence possibility. And to the extent that either one of those things are something that you do, are you going to give people reinstatement rights? If so, for how long? Et cetera, et cetera. So, and what we've seen here, and we'll talk a little bit more about this, is court actions where people are going into court and trying to get various components of these things enjoined, basically get a court order saying that whoever's issuing the mandate can't enforce it. And those put your consequences in a state of flux as well. You thought you had a date, you thought you had a consequence, and now a court has said, wait a minute, you can't enforce some or all of this. And so those are things to certainly keep our eye on as well. Some other overriding considerations when we're talking about vaccine mandates are whether or not you have a bargaining obligation in a unionized context. Most likely you have an impact bargaining obligation, as we've been talking about. For those of you who are implementing your own mandate, you might have a decisional obligation as well, unless you've already got that contract right. And many employers do. We've also seen a lot of questions about adequate staffing, whether people are going to be able to staff their functions if there's a vaccine mandate. In the context of the government mandates, especially in healthcare, we've seen a lot of employers be very concerned that they can't really afford to lose any staff, especially during a pandemic. And so the consequences there have got people pretty concerned. But even in a private setting where you're contemplating your own mandate, you have to take into account whether or not that's going to create some staffing issues for you down the road. And then the other thing, and I think Dan may talk a little bit about this when he talks about litigation later, but your liability concerns. What if you do and what if you don't, kind of thing, and how is that going to impact your liability in a litigation context? So there's frankly a lot of food for thought here on the vaccine mandates. Okay, so now I want to talk about some of the specific mandates we've seen. I'll start off with the healthcare mandate from New York State, and I won't belabor the tortured history here again this week because I had a very similar slide last week. But the key point to note is the New York State healthcare mandate does not include a religious exemption. A court proceeding was commenced, basically challenging the mandate on that basis, and a temporary restraining order was issued by the Federal District Court for the Northern District of New York. That temporary restraining order has been extended from through October 12th, and so now we're anticipating some sort of decision from the court, on or around October 12th. The governor has indicated that she does not intend to back off from either the mandate or from the intentional decision by the state not to include a religious exemption. So this thing is set up for, kind of an interesting showdown between the litigants in that case in the state of New York. We'll see how that comes out. We may not have an answer on this for a while because once we get a decision from the Northern District of New York, I think we can anticipate that there's a strong likelihood that the losing party, whoever that is, might want to appeal that thing to the Second Circuit. Okay. So what's in those emergency regulations? And this is, again, sort of what I talked about before, but these are the key things you want to be thinking about with respect to any of the mandates. This particular thing is a vaccination mandate with no test out, includes a medical exemption, but no release exemption. The effective dates, yesterday at the end of the day was the deadline. So really effective today for general hospitals and nursing homes. And then October 7th for some other covered entities. And it's a pretty broad listing of covered personnel. The only people who would not be covered here are those who can, do their jobs remotely, completely effectively and remotely. Okay, so let's talk just a little bit about the medical exemption. The standard that's set forth there is generally accepted medical standards, and that's the thing to keep in mind. I think if you're imposing your own mandate, or if you are trying to follow other mandates that have been imposed upon you, the medical standard for approving the accommodations is going to be pretty important. And the state has issued some guidance on this, and it's fairly narrow guidance. It's not just a doctor's note saying, in my medical opinion, I don't think Pete Jones should get this vaccine. It has to be tied to a particular condition that's contraindicated for a fairly limited set of reasons. So there's also been clarification now that testing is not required. If someone is eligible for the medical exemption, they don't have to test out. They can just work without testing. Now, some employers have been grafted their own testing on top of that, so that's something to think about if in that context. The religious exemption, again, this is the source of really all the dispute at this point, that there wasn't one in those emergency regulations. But if it is ultimately determined by the courts that a religious exemption is required, you would be looking at two things. You'd be looking at whether the individual has demonstrated a sincerely held religious belief. That's a fairly low standard that people can establish if they are able to say that receiving the vaccine would contravene their religious beliefs, but they need to connect those two things. It can't just be a generalized objection or some sort of concern about the science. It has to be tied to their belief system. But the second question is the undue hardship standard. Even if a religious accommodation ultimately is required under this emergency regulation or any other regulations, you'd have to look at whether or not letting people work is an undue hardship. And that involves some sort of case-by-case assessment. So those are things we need to keep our eye on. I would recommend that even if you're going to deny the request for a religious exemption, let's just say that the regulation is ultimately sustained as written and there's no religious exemption for in-person work, I think you still want to be processing those religious accommodations and documenting those results. It's possible that leave might be an accommodation. It's possible that remote work. There are at least some other possibilities here. So, okay, New York City. So moving off that and moving on, I wanted to just touch briefly on some of these local orders. I mentioned those before, and the New York City Department of Education has promulgated an order mandating vaccination. And we have sort of an interesting history as well. There was a court action commenced, the state court issued a TRO. The order from the Department of Education's Office of Mental Health was then revised to add a sentence that said all applicable accommodation processes will be followed. The state court then was satisfied, issued a written decision, and vacated its temporary restraining order, said as long as you've got the accommodations in there, I'm not going to restrain you from enforcing this. Then a separate action was commenced in a federal court for the Eastern District of New York, citing 14th Amendment due process concerns. That court denied the injunction. The Second Circuit, which is the appeals court, temporarily issued an injunction pending a hearing. Then yesterday, that was vacated by a 3-judge panel. So you can see where, depending upon the level of review, depending upon the court, we've got both state and federal, these rules are now subject to challenge by a lot of different people, and we're getting some interesting and perhaps even contrary results as the various proceedings go forward. So this continues to be something to keep our eye on. Okay, another executive order in the city of New York. We've reported on this in the past. I think Sarah Luke talked a little bit about this, but the key to NYC Executive Order imposes a mandate for restaurants, indoor entertainment, sports venues, fitness centers. Does not include a test out, but does include medical and religious accommodation provisions. There's some exceptions for de minimis activities like deliveries or people who may just stop in to use a restroom. And there's also an exception which includes masking and social distancing for certain out-of-town performers and athletes. We'll see whether when the NBA games come to town, whether anybody is playing in a mask or whether they've all been vaccinated or whether they choose to try to flaunt this executive order. There's also a court action pending on this. Just yesterday, the court indicated that it wasn't going to issue a decision until October 8th. And so notwithstanding the plaintiffs' concerns about irreparable harm in the interim, to the extent that this order is applied to them, for right now, the executive order applies, and the venues are the ones who are charged with implementing this order. It's sort of an interesting approach that the executive order imposes the obligations on the venue. Okay, so on the federal side, I mentioned this, President Biden has announced a multi-point federal approach. One of the things that he announced was the emergency temporary standard from OSHA. We haven't seen that yet. Word has it that OSHA was a little bit not ready for this, I guess would be the way to say it. And so I guess they're working on it, but nothing's been issued yet. On Friday, federal contractor guidance was issued. And that guidance has indicated that vaccination will be covered, will be required of covered employees except where there's an accommodation in place. And also requires that an individual be designated. It's going to apply, it looks like it's going to apply to federal contractors and subcontractors, the so-called flow down provisions that have been included in the guidance. And the date, currently the date is December 8th, 2021. So these would be basically incorporated in federal contracts and make vaccination a requirement there. Wait and see. I think if history's any guide here, we're going to see actions challenging this as well on the same theories. It seems that these theories are going to be with us for a while, and we'll wait and see where it finally comes out. Remember that the posture that we're seeing right now is an injunction posture, which is to say that the court is being asked to stop things before they play out. It could ultimately be determined that some or all of these things are not appropriately issued, and then you'd be looking more at a damage posture, at least in theory. So we'll see where all this goes. Okay, I've taken a lot of time here. I wanted to cover a lot of ground. Let me just leave you with a couple of final thoughts. Don't forget your bargaining obligations. Stay tuned on the emergency temporary standard. Still haven't really heard from OSHA on that, but that's a big one. Applying to the large employers with 100 or more employees, at least that's the preliminary indication. Keep your eye out for other applicable mandates in the hospital setting, the healthcare setting. We're expecting to get additional mandates from the feds, and so we have to keep our eye on that. I know that everyone's got concerns about staffing issues. They had concerns before we started talking about mandates, and they continue to apply. So we'll have to see how that plays out. The HERO Act is a backdrop requirement in New York, so keep that on your radar. And I think Stephanie's going to share a few thoughts with us on the latest updates there. And don't forget your PPE. Andy, that's it. I apologize for the breakneck pace, but I wanted to make sure I covered a lot of ground here for everybody. A lot going on.
No, there is, Keith. Very, very helpful, all of it. Just a reminder too that to our attendees that this is recorded. We publish all of these webinars on our website. You'll have access to it. I check back frequently to look at this information and encourage you to too. So Pete, thanks for that. I think we covered everything. One interesting element, we did get a lot of questions on the federal contractor piece. So that might be something worthy of a separate breakout session, either as a standalone or next week on the webinar. And just to let attendees know, we'll take your comments and questions into consideration and try to get you more guidance on that. Pete, thanks again. So next up, we have a webinar regular here and a great contributor on all things labor and employment related here at Bond. Stephanie Fedorka. Stephanie, great to have you with us. Stephanie, again, has kept her ear to the rail on the HERO Act and happened to notice what struck us as a pretty significant development by way of the guidance that the state has published, and wanted to speak with you all for a couple minutes on that subject today. So Stephanie, great to have you with us.
Thanks, Andy. Always a pleasure. Thanks to everyone for joining us. Just a very quick update. It seems that the Department of Labor has updated their model plans. If you recall, they have those model plans available on their HERO Act website, and they have made two significant or key changes, in my opinion, that we're going to talk about. Next slide, please. The first is with respect to face coverings. You'll recall if you adopted the model plan that this was the provision that was in there, mandating that employees wear face coverings throughout the workday to the greatest extent possible, and face coverings and physical distancing should be used together whenever possible. Well, next slide, please. This is what we have now. So there seems to be two options here. It seems to clarify and allow for a very narrow option for employers who have workplaces where every individual is fully vaccinated, as defined by, we previously defined it as 2 weeks from that last second shot in that 2-dose series, or 2 weeks after your Johnson & Johnson shot. That's the definition of fully vaccinated under the CDC and state guidance. So if you have all individuals on the premises, it seems to be more than just employees. Then this suggests that masks are not required. They're recommended, but they are not required. I think that's a pretty narrow exception for those workplaces that are completely vaccinated. Otherwise, for the most, number one, we still have that same language. Employees will wear appropriate face coverings in accordance with guidance from the CDC and the State Department of Health. So I think what this means, practically speaking, is for workplaces that you think you may qualify, if you have 100% vaccination, fully vaccinated. What we don't know, this leaves some questions because the FAQs have not been updated. We don't know if there will be any further guidance on if you're fully vaccinated, but the only people who are not vaccinated perhaps are those who are legally entitled to an accommodation. This language doesn't seem to indicate how the Department of Labor might fall on that issue, and we don't have guidance yet. So stay tuned. We may see updated guidance in their FAQs on how to treat that, or if this is going to be reserved for 100% fully vaccinated, no exemptions, period, workplaces. Next slide, please. The second update that I noticed was in the physical distancing section. This was the original language. Use a face covering when physical distance cannot be maintained, that last sentence. And then next slide, please. This is the updated sentence or provision. It removes that last sentence. So to me, that perhaps, it's a little bit unclear what the intention was there. I think it's to reemphasize that either if you're in a workplace where that second provision might apply, that it doesn't conflict. But again, it's a little bit hard to decipher exactly what that intention was, except for if it's not to avoid confusion. If you are falling into that second provision where you're fully vaccinated, you don't have to require your employees to wear masks, then that provision was removed to avoid any confusion there, perhaps. So those are the biggest updates. There were a couple other minor updates. For example, on that first page, if you are familiar with the model plan, there was some language in there that says, as of the date of the publication, there is no designation in place. That section has been removed. But again, I think these are the two key updates that we wanted to provide you. I think it's a good opportunity to review your circumstances and determine if you do fall into that second provision or not. But it may very well be that is a very, very, very limited number of workplaces.
Thanks, Steph. So a number of questions on this, and just everybody attending, we'll take a look at those, and I expect we'll have more guidance on this moving forward. Steph, can you just in this number 5 here, what provision did they take out on the physical distancing? Just remind me.
Yeah, they took out, so if you go to the previous slide, please. That last sentence, use a face covering when physical distance cannot be maintained, as well as, I guess, hold on, next slide, please.
Yeah.
Yeah.
So the
and
implication,
the sentence before that.
So the implication, am I right? The implication before was that if you are distanced sufficiently, then masking would not be required, and that they've eliminated that potential interpretation. I have that right?
I think so, yes.
Okay, yeah. Yeah, so we're trying to piece this together for folks here. Stephanie wrote a great article for our blog on this, and that'll be published later today too. So please keep your eyes out for that, and keep your questions coming. Steph, thanks again. All right, next up, Dan Pouts. For those of you who have attended these webinars, Dan is also a regular contributor. Dan is a partner in our litigation department here, and during the course of his practice has been keeping an eye on various litigation-related matters falling under COVID. This is something that I think initially we all had our eyes out for. There seemed to be a number of potential COVID-related pitfalls out there. And at least initially, we didn't see this flurry that we maybe otherwise expected. But with that said, Dan has seen some developments of late and has been keeping tabs on this, and asked to talk with you all today to give you some updates there. Hey, Dan, thanks a lot for you being with us.
Andy, I appreciate it. It's nice to be with all of you. It's been a while, but as Andy mentioned, we have been keeping tabs on what's going on. And just to kind of set the stage, there were several months where courts, were operating obviously lower efficiency in terms of in-person, and compliments to judges, particularly the state court judges, both here in Syracuse and counties elsewhere, for utilizing these web-based platforms, Zoom and Teams, in order to continue the wheels of justice moving, so to speak. And what we've seen is, as Andy mentioned, we anticipated, and frankly, in some ways we've seen a flurry of litigation, but because the wheels of justice often move slowly, a lot of the cases that we're litigating right now and that we're waiting on court decisions were matters that arose in the spring of 2020 or summer of 2020, because these claims took a while to develop during discovery. However, now we are back to in-person jury trials, though courts, judges continue to utilize the technology available to us, both for settlement conferences as well as depositions and things like that. But a lot of these cases are settling. Cases that we deemed previously to be unsettleable are settling. And that's, at least in my opinion, the feedback we're getting from our clients is primarily because in terms of trials, you're looking at 18 months out before you can get a jury impaneled to hear your case. And even in the Division of Human Rights, when we're looking at a year or so before we can get a public hearing. So, a lot of these cases are settling, which is always a good thing. And a lot of times we're utilizing ADR, alternative dispute resolution, either mediating it or arbitrating it. So we are continuing to get results for clients, just in a different way, which a lot of us are doing in a lot of different industries for the last 18 months. That said, there's really there's what I would deem to be three different types of cases and three specific types of disputes that we have seen a lot of and that we've been involved a lot in. The first is actions against insurance companies based on what we would deem to be business interruption claims or loss of income claims. There's been a tremendous amount of those, and as I'll mention in a minute, the decisions on those have been one-sided. And we think because of that and because of the jurisprudence that's already come out, that issue may be, for all intents and purposes, dead. And I'll explain that in a minute. The second type of cases that we've been involved in and that continue to evolve are actions against not just wedding venues, but party venues for breach of contract actions. A lot of that involves deposits, return of deposits or not. Thankfully, a lot of those cases have settled, but we still have some of those kicking around, and I'll explain those in a bit. And the third type of case, although it's not in itself a theory of liability, but the concept of force majeure that I've been on this webinar in the past a couple of times talking about, it's a legal defense in a contract case that essentially says, because of an act of God, I could not perform my contractual obligations. And there's been a significant amount of case law, primarily outside of New York, dealing with whether or not the COVID-19 pandemic constitutes an act of God for purposes of force majeure. So that's kind of the overview, and I'll drill down on each of those three matters or types of matters very briefly. So in terms of a business interruption claim, all of us know, many of us on this call, we have business interruption coverage through our various insurance policies. And interestingly, a lot of us don't look at the specific language in these policies, but since the onset of the pandemic, the primary issue before the courts is whether or not this business interruption coverage applies to, losses related to the COVID-19 pandemic generally, the shutdown orders that have resulted from the pandemic, or even specific contamination in our buildings. In other words, if folks within our building were positive for COVID, is that a basis, and we had to shut down because of that, is that a basis for a business interruption loss? So what we found it's almost universal in these types of policies is that the loss of income coverage provides that the carrier is responsible for paying loss of business income due to a suspension of operations. And here's the key language here: a suspension of operations that was caused by direct physical loss of or damage to property. So the question that's been litigated throughout New York State, both in federal and state courts, is whether that requires the policyholder to prove some form of actual physical damage to their premises in order to be eligible for business interruption or income loss coverage. And fortunately for the insurers, unfortunately for the policyholders, courts in New York have universally agreed that loss of use caused by the pandemic must require physical damage. The loss of use alone is not physical damage. And the loss of use, as contemplated by these insurance policies, that must have some connection to physical damage, alteration, or compromise to your property. And we've seen this decision come out in many, many, many different industries. We've had catering business that's had to suspend its operations because of government shutdowns. Courts have said, no, your policy doesn't include that type of loss of use. Medical offices that have closed down, dental offices, art galleries that suspended operations in accordance with government shutdown orders, a printing press, restaurants, the list goes on and on and on. And not only have these decisions come out in federal court, state court, all over the state, all of the district courts within New York State on the federal level, and then mostly Supreme Courts downstate. And as I mentioned earlier, we think this issue is pretty much dead on arrival because we have not seen a contrary opinion issued by any court. Now, outside of New York State, there's been more favorable decisions to the policyholders, but we just haven't seen it here. And one interesting point on this, because in these cases that have been litigated, a lot of the policyholders have tried to draw comparisons to the wake of 9/11. And the courts here, at least two courts, decisions that I've seen, they've said, no, this is not a post 9/11 situation, because in post 9/11, there was buildings that, even though they weren't, physically, raised by or affected by the buildings falling, the towers falling, there was, chemicals and noxious fumes that were in the building or in the, the furniture, whatever in the building, that's where the physical damage came from. And here, despite the fact that you said, look, we have workers here that have tested positive or patrons that have tested positive for COVID, courts have not bought that and have not drawn a comparison to the post 9/11 type of physical damage that we saw. So I would not anticipate a tremendous amount of more litigation on this topic, but obviously if there is, we'll stay on top of it. Secondly, as I mentioned at the outset, these are these actions involving wedding venues and party venues. We found them to be very emotionally driven. The ones that have not settled, which thankfully are very few, it's sort of, they've gone to the mat and they've resulted in some interesting jurisprudence by the courts. Now, what we've learned overall in handling and following these claims is that, unlike the insurance policies that I talked about before that have pretty universal language throughout, the actions involving party venues are very contract specific. Each of these venues has their own contracts, has their own language. Some are much more complex than others, but what we found are the decisions from the courts rest entirely upon the specific clauses that are contained in these contracts that vary from venue to venue. There's one interesting case down in Westchester County that I just recently read a decision on. It was parents, mom and dad paid a deposit for their son's bar mitzvah. And this was back in the summer of 2020. And they were informed by the venue that because of certain restrictions, government restrictions, that the venue would not be available on the desired date. And so the parents said, well, that's okay, we'll find somewhere else. But then they demanded a refund, to which the venue replied, we're not obligated under the contract to provide a refund. We can, however, offer you alternative dates. Well, of course, that issue was brought before the court, a Supreme Court judge down in Westchester County, who basically, there was a couple provisions in the contract, specific provisions that they picked out. And the first provision involved the caterer. What the contract said was the caterer does not have responsibility or liability if they cannot comply with the contract due to causes beyond their control. So here the caterer said, look, it was beyond my control. These government shutdowns, I didn't have any control over that. And because of these shutdowns, I couldn't provide the venue on that date. And the court said, no, you're right. That's exactly what the contract says. However, the contract doesn't say anything about not returning the deposit. So that was an unavailing argument made by the venue. The second, and frankly, the most important clause in the contract that the court latched onto was that it did address the security deposit and the failure to return the security deposit. But that was only in a situation where the purchaser, I guess you would say, failed to make the required payments. And here, because that didn't happen, the court said, you don't have any right to retain the deposit. And what I would say is the most interesting part of this situation and this decision was the court was very hard on the venue in saying, look, this is a completely one-sided contract, right? You essentially, you reserve the right to cancel under any circumstances, and you give the purchaser really no rights. And the contract was so one-sided that the court said that even if these other provisions and this other analysis didn't apply, the contract wouldn't be enforceable anyway. So the takeaway here is that if you are in this business or in this line of work, I would strongly encourage you to reach out to counsel, just have somebody take a quick look just to make sure that, you know, this contract is not impermissibly inequitable like the court in Westchester County just found. And we thought, at least coming into the summer of 2021, we thought that these these venue-related cases were probably going to go away because of things were opening back up. The government restrictions were coming less and less. And now with the onset of the Delta variant and what's happening with that, I think these types of cases are probably going to be around for a little while longer. The last thing I want to touch on very quickly, because I know Andy has some other things to say, is if you folks were on, gosh, it's up to a year ago, maybe more than a year ago, we started talking about these force majeure provisions, these act of God provisions and contracts. And unfortunately, to date in New York, we don't have a lot of clear guidance on this. A lot of these cases have been settling, particularly in the commercial real estate context. There was a recent filing by Jay-Z's company, Rock Nation, against their landlord down in the city. And that is based on, they essentially said, look, number one, we've been trying to sublease our space forever and the landlord wouldn't respond to us. And secondarily, we couldn't pay our rent because of circumstances beyond our control, specifically the act of God, which was the COVID-19 pandemic. That case has not been decided yet. There's been no temporary relief issued, so we don't know where that's going. But if decisions made in other states are any indication, establishing that COVID-19 is an act of God, we found that that's the easier hurdle. Courts have universally agreed, yeah, we do believe that COVID-19 is an act of God. However, the biggest problem is that you need to show that your failure to perform, that COVID-19 is actually causing it. So in other words, if my business stays open, but I'm just having lesser customers or lesser income, that's not an act of God because it didn't necessarily close down my operation. And there's been a number of these cases where courts have said, sure, it's an act of God, but it didn't totally prevent you from performing. In fact, there's only one case that I'm aware of that's out in Chicago. It was a restaurant that argued that their obligation to pay rent was relieved because of COVID-19 and force majeure event. And the court agreed. And what they specifically said was in the state of Illinois, when they implemented a stay-at-home order that prevented the restaurant from providing on-premises dining, that was sufficient to excuse their performance under the contract. So again, these are all issues that we will continue to follow. If you have any questions, please feel free to reach out to your bond attorney, but we'll continue to fight these fights and we'll continue to monitor and keep all of you updated. So thank you again for your attention, for your patience, and Andy, thank you again for having me.
Danny, great to have you, buddy. Thank you for joining us. Good stuff. Definitely hope you can report back on any developments you see in these areas. Do I know our clients and friends of the firm are interested? So we have just a couple more minutes here. There were a few things that I wanted to cover for folks. Katie is out this week, so I will be doing my best to fill her incredible shoes in providing these updates. I won't even try to go into depth on the Albany affairs, but did want to at least include the regular chart and slide that you're used to seeing on Katie's presentations here. I noted that the trends are more positive than we've seen. We are starting to see the decline in terms of the number of new reported cases. So we've peaked and started to decline. We're seeing good trends in terms of the hospitalizations, not so good on the number of deaths. And I think looking at this, what grabs my attention obviously is where we're at right now in 2021, and then looking back to where we were in August of 2020. And of course, having a large percentage and majority of our population having received at least one dose of the vaccine, and yet seeing that climb in the new cases. And then, of course, last year we saw what the late fall and early winter months held. So hopefully we won't see that trend continue here and that the downward trajectory will continue. Additionally, I tried to just put some quick thoughts together in terms of things that I'm focusing on and giving consideration to that I think are relevant to your businesses and your organizations. If you'll see on the next slide, I've given some bullet points here on what those are. I think first and foremost, for those employers here in New York or with New York operations that have elected to voluntarily participate in the expanded and extended FFCRA. That program, that federal program, is set to expire at the end of this month. I'm not hearing about any legislative initiative in Congress to extend that program. It could happen, I suppose. I have not seen it. If that does happen, we'll let you know. But assuming the end of the month comes and goes, just a note that employers should remember that New York's COVID emergency paid sick leave, and again, that is covering a situation where an employee is subject to a governmental quarantine order and some potential extended circumstances under state guidance, can be afforded paid leave during that quarantine period. There's also the possibility that in circumstances that would have been covered previously under the FFCRA, New York's PFL or paid sick leave programs could also apply. So just keep those in mind. We could very well, in a number of circumstances, be slotting in a new paid sick leave benefit under state law that to this point had been essentially rendered moot by our participation in the FFCRA. I think another trend we're starting to see is with the push on vaccination mandates, we're seeing a number of entities take action, either severing their employment ties with healthcare staff or placing them on leave. And of course, this is having a negative impact on healthcare delivery. And how is this going to work exactly moving forward? I know it's a concern that I have on my end. I'm sure my partners do, and our other attorneys here do too, as well as you. We saw just yesterday, I believe, Governor Hochul issued an executive order attempting to address some of these drastic staffing issues that we're seeing, and I think that are a concern that we'll continue to see given the vaccination mandate. But we're seeing this tension between these two issues, and I think it remains to be seen how that'll get resolved. I wanted to mention a few stats too, just very quickly. Again, unemployment continues to persist. Here in New York, we have a rate that, as of July anyway, was still considerably higher than the national average, even though we did add quite a few jobs then. And of course, in New York City, we're seeing even a higher rate, nearly double the national rate. This, I think, has dovetailed into a number of issues, as you'll see on the next slide. One is that we have, the good news is we have a tremendous amount of vacant jobs that are out there. I think on the next slide, you'll see the specific statistic there of over 10 million, nearly 11 million job vacancies as of July that were in the market. Problem being that we only have 8.4 million workers who are unemployed and presumably looking for work. So quite a sizable gap there. And I'm sure, and this will be the subject of Bond's fall breakfast briefing, but you're seeing, I know, as employers, tremendous pressure and an incredibly tight hiring market right now. And as a consequence, employers are having to, in some circumstances, raise their compensation in order to attract workers from other areas or to retain workers. Again, we've got this significant gap between the number of vacancies that we have available and the number of workers. And there just aren't enough right now, according to the statistics that are compiled on this. With those rising wages and other circumstances that exist in the market, we are seeing a rising inflation. Unfortunately, this is an issue that is very politicized. It's hard to get, very clear data on where things sit on this. But if you look at the Federal Open Market Committee, I think they've indicated, at least based on some of their measures, that we are seeing higher than usual inflation. Some place it at close to 4% or just under 4%. Again, it's going to depend on the measure there, but it's clearly present. I work with a number of employers in the transportation industry, and for me, this is always a bellwether of what lays ahead for our economy. And I think you are seeing in the transportation and the trucking and the logistics industry a rise in inflationary indicators there. I saw a statistic that if you went back 18 months before the pandemic, it cost about $2,000 to ship a container from China to the United States. Right now, that same process is running about $16,000. And the major transportation companies are indicating a significant increase in their cost to deliver products across the country and globe. And of course, ultimately that will translate to higher prices and inflationary pressures. So just keep these points in mind. There's a good article that I linked to there that I think gives a good overview of what may be ahead on this front. Certainly that will impact your business, and we just wanted to pass that information along too. All right, everyone. Sorry we went a little bit over there. Wanted to share that information with you. Here you have the contact information for our presenters. Please feel free to reach out to them with any questions you have about these or other matters, or please let me know. Again, we appreciate your feedback. If you can complete the survey upon close of this, we take that information under consideration, and it's very valuable and important to us. So thanks to everybody. Be well and be safe.